wonderful and unique session on taxation by our advocate Shashank Dundu sir. Now I request Deepak Ladda, chairman of the branch, to give his welcome address, please.
Thank you, Secretary Ravi Shankar Reddy. Respected Speaker of the Day, CA Shashank Dundu sir, Advocate Shashank Dundu sir. My colleague in the Managing Committee and SICASA Co-Chairman Sharan Kumar Uppalpatti, Senior Member Ramdev Bhutrayan sir, who has already joined, and all my fellow members. A warm good afternoon and good evening to all of you. Advance Deepavali wishes to all of you, because pre-Diwali, this is the last session of the branch, CPA branch. Then the sessions are post-branch. Sir, at the outset, thank you for accepting the invitations on a very shorter notice. I know the tough schedule which you have and the hearings which you take place. I should thank our past chairman Bhanu Narayan sir, who has coordinated with you and given us the time slot available for you. Thank you, Bhanu sir, in your absentia. And Shashank sir, looking forward for a wonderful session next 2 hours. Friend, the topic of the title, the idea of the topic came when one of you CA members called, Deepak, why don't you keep the topic on disease entities persons, because there is a lot of confusion as how the liability will pass to the legal heirs. When he gets the property only, the liability exists, or even there is no asset being passed on to the legal heirs. What is the status of their liability? Because legal, after COVID, this problem has come because there was a sudden impact. There was no planning by the members. Sorry, there was no planning by any sudden death in the family members happened. So there was a lot of confusion. Many CAs, every CA is facing these questions from their clients or via or direct or indirectly, that what about the status of the demand? What is the status of the assets that has kept in, how to file returns? We have a clarity as to how to file return, but the legal issues and the practical still continues. I think Bhanu sir is joining.
Yeah.
So welcome, Bhanu sir.
Welcome. Thank you, Chairman. Good evening to all.
Thank you, sir, for lining up this session for us.
My pleasure.
Yeah. So, friends, this is all from my side. Thank you for the opportunity. Over to you, Secretary, sir.
Thank you, Chairman, sir. Sir, welcome. I welcome our past Chairman Bhanu Narayan sir and our Management Committee member Sharan Kumar Uppalpatti also. Now I request our Sharan Kumar Uppalpatti to introduce today's speaker.
Yeah. Thank you, Secretary, for the opportunity to introduce today's speaker, Advocate Shashank D. Friends, he enrolled with Bar Council of Maharashtra and Goa on 5th February 2016 and joined the Chamber of Dr. K. Shivaram, Advocate, received exposure and experience in indirect tax during the years 2016 to 20.
Direct tax.
Direct tax. From February 2020 onwards, joined the chambers of Sri D. Manmohan. Who is the retired Vice President of ITAT. Have been a professor in Siddharth College of Law on part-time basis for almost 4 years in Mumbai. Appears in Telangana as well as in Andhra High Court and ITAT. With this brief profile, I introduce before you all Advocate Shashank D. Over to you, Secretary, sir.
Thank you, Sharan Kumar, for the brief introduction. Before our speaker start the session, I request our past Chairman Bhanu Narayan sir to say a few words, sir.
Thank you, Ravi Shankar, and Chairman and members of the Managing Committee and the learned speakers, Shashank Dundu. Today is a very important topic, taxation of deceased persons and defunct entities, because we get a lot of queries from members asking as to what will be the tax liability once they receive a notice after a person has died or a company has become defunct, and they get notice about tax dues or TDS penalties, prosecution launched for under section 276 capital B. So all these issues are a little complicated and offbeat, I can say, which are not in the regular routine items. They require some specialist advice and they require some special study, case study. So the chairman was very keen to have a discussion by an eminent advocate on this issue. And I'm thankful that Shashank Dundu has accepted to share his knowledge on this aspect with us. And towards the end, maybe we'll ask some more questions and get further clarifications. Thank you. Thank you very much.
Thank you, Bhanu sir. With this, now I request the speaker today, Shashank Dundu sir, please. It is over to you, sir.
Thank you. Thank you so much, sir. Thank you so much, everyone. I'll directly start with the topic. In fact, when first time sir had mentioned about this topic, I was like, it is a small section. How much will I say? This was the first question I asked him that, how many hours do I need to speak? And he said 2 hours. I said, the section gets over in half a page as per the Income Tax Act. How do I expand that to such an extent? But once I started going through it properly, with all the legal precedents, I realized that, it will take more than 2 hours and, multiple sessions. So anyways, without further ado, I would like to share the screen to have the PPT so that everyone can view it. I hope it is visible.
Yes, sir.
Yes.
Yeah. Taxation aspects of a deceased person or a defunct entity. Now, normally, you must have heard this from that no one can escape taxes and death, which has been said by Benjamin Franklin. So I thought instead of that, I will change it a little and mention it as even death cannot spare a person from tax, just for the cliche effect, of course. Now, firstly, this started in the year 1992, wherein under the Income Tax Act 1992, Section 24B mentioned about this aspect of what happens in case of SSC has died. But however, later the 12th Commission of Law report recommended changes because it mentioned that the main idea behind the section was unable to be properly put forward in the section. And it did not deal with the step-by-step proper various stages at which the proceedings might stand at the time of death. So in view of the same, as per the 1961 Act, as we know now, they have recommended a few changes, but I'm telling this so that we know the basic reason behind why a few changes have been made and what is it that we need to focus on. It is very important for us to keep such things in mind. So the following steps were recommended. Firstly, what happens where a person dies before any proceedings of assessment of the income have been commenced? In case there is no this thing have been commenced at all and the person dies at the time of during any financial year and no proceedings have yet been initiated, what happens then? What if the proceedings for the assessment, that is a notice under section 142 143(2) or 148 have already been issued, but however they have not been completed, then what should we do? And what if the assessment proceedings have also been completed, but notice of demand has not been served, that is the arrears have not yet come into being? And the last one, in case where the assessment is over, the notice of demand is also has been issued to the SSC. When I'm talking about issued or completed, it's in respect to the SSC. In respect of the SSC, it's over. He's received the notice of demand also, but however, after that he expires, then what happens? Because the tax has not yet been collected. Then what do we do? So a few recommendations were there. We'll come to that, but to have a step-by-step understanding, let us first understand that what are the basic steps to be taken. Now, section 159 deals about this, wherein it's a machinery provision intended to enable an assessment in case of a person who is dead till the date of death. And thereafter, who has to come and pay taxes on their behalf? In case there is a testamentary succession, we'll come to that. Now, the first step, in case an SSC dies at any time during the financial year, the family or the close relatives must obtain a legal heir certificate. Now, why am I coming from this aspect, from this stage? Because these are the basics that a lot of people do not know of. In fact, recently I had a client who had come and they had mentioned that I had a client who had come and they had asked me, what should I do, sir, now? So I simply mentioned that go and obtain a legal heir certificate. But the questions they asked me is how to do that. These are the kind of basic questions that we never answer for ourselves, and we can't wait for something to happen and then decide to go ahead. Even tomorrow, if a client comes to any of the practicing chartered accountants, they should be in a position to at least tell. Otherwise, they will have to again hire another advocate or some other person to do this particular aspect and pay extra fees or money. Now, firstly, who's considered as a legal heir? We are saying get a legal heir certificate, but we need to understand who needs to go and approach, and for that we need to understand who will be considered as a legal heir under law. It's not a simple case that yes, there's my brother, sister, son, daughter, mother, father, or someone, and they will go and take it. So for this person, if a person fails to make a will or a testamentary document, now when I say a testamentary document, it's nothing but a will. That is, you're writing down as to what happens to your property after you die, determining who will be the legal heirs or who will handle the estate of the person after the death. Then the Hindu Succession Act will apply. In case we don't make a will, then the Hindu Succession Act, which is a codified law, that will be applicable. However, in case you actually make a will or a testamentary document before you die, then the Indian Succession Act will apply. But if there is nothing mentioned and a person dies intestate, whenever I'm saying intestate, these are all legal terminology. When I'm saying they will die intestate, which means that they have not made a will. In such a case, Hindu Succession Act will apply. But whom will it apply for? Don't go with the name Hindu Succession Act, so it should only apply to Hindus. They have also considered that Hindus means Buddhists, Sikhs, Jains, etc. For Muslims, they have heirs under Muslim Personal Law, Shariat Application Act 1937. And then for Christians, the Indian Succession Act applies, section 32, if I'm not wrong. Now, if the person creates a will, as I already mentioned, the provisions of Indian Succession Act will apply. Now, why do we need a legal heir certificate? Now, this legal heir certificate is provided by the government to in fact determine the rightful owner of an asset. So it will be useful in a lot of places. This will in fact verify the relationship of the deceased with you, because of which you can also use it before the income tax department. You can use it at various places to even obtain. You can also mention it to the bank account in case it is only mentioned, the bank account is only in the name of the deceased. Then you can write a letter to them stating that, now any income that comes to them may be transferred to me because I'm the legal heir. There you might need to use this legal heir certificate and various other places. So hence, the first thing that they must do is obtain a legal heir certificate. Now, how to determine who are the legal heirs? That is as per the Succession Act, as I've already mentioned. I guess there's a repetitive slide. Now, for quick understanding, this may not be really useful, but understanding is very important. It is of prime importance here. So, as per the Hindu Succession Act, if it is done intestate, when I'm saying intestate, no will. Then in this, when I'm saying class 1, all these people mentioned here, they will get a share equally. After the date of death, anyone or all these people will be considered as the legal heirs. Understand, I'm not talking about a legal representative, I'm talking about the legal heirs. A legal heir can be a legal representative as well. So legal heirs, once after the date of death of the deceased, when the properties, how the estate of the deceased must be distributed is mentioned here. So this is how a person can be called a legal heir. Any of these people can go and apply. In case, that was the class 1 heirs. Now, in case the class 1 heirs do not survive or none of them are available, when I'm saying the widow, that is the wife, in case the husband is expiring, then mother, son, daughter, in fact, deceased son's daughter, deceased daughter, and all these line of people, none of them are there because of some reason. Then we go to the class 2 heirs. Now, what are the class 2 heirs is again mentioned in the Hindu Succession Act, in the schedules. In the schedules of it, all these particulars have been mentioned. Here again, they have mentioned that this will be distributed equally between any one of the entries. When I'm saying any one, it comes in the hierarchy. When I say hierarchy, as you can see on the screen, you see entry 1. It's mentioned father. Father has somehow been categorized as a second-class citizen here. So the first person who can claim out of the estate is father. The entire, if there's no one in class 1 heirs, then class 2, entry 1, only father will receive the entire estate. If father does not exist, then entry 2. But in entry 2, again, all of them will get equally. Daughter of sons, daughters, etc., etc. Again, the same thing gets repeated. Entry 3, entry 4. And it's all in hierarchy. They all don't get it at the same time. If entry 5 fails, then entry 6 comes or entry 7 comes. Now, worst case scenario, let us, for example, presume that even they have expired, they are not available for some odd reason, they are not available. So now, who else will be considered as a legal heir? They are agnates and cognates. These are again legal terminologies, but basically agnate means when they are related to each other through blood or adoption, wholly through males. Now, this is an archaic legislation, because of which they have given a lot of importance to males. So, everything will be referred from the point of view of males. However, there have been amendments because of which women get equal rights. Now, first, agnates will get it, that is, who are wholly through males. And in case no one is available wholly through males, then the persons related to each other through blood or adoption, but not wholly through males. Not wholly through males will be referred as cognates, who will be the legal heirs. So, and generally we don't come down to such a situation. We end up somewhere in class 1 or class 2 at best, wherein we do find the legal heirs. And here I just wanted to point out that in case Hindu female is dying intestate, then she also has a hierarchy wherein all these people equally will be distributed. I mean, they will be distributed, the estate will be distributed among these people. And for the purpose of Muslim law, as I already mentioned, Shariat Application Act, as per the personal law, it will be mentioned, and Indian Succession Act will not apply to Muslims. And however, for Christians, the Indian Succession Act would apply and not the Hindu Succession Act. So once we understand all this, we know the basics as to who is a legal heir, which a lot of us do not know. I'm telling you, even the lawyers fail to understand this, because they all read the act, but ultimately they don't go to the intricacies wherein, even the schedules they need to know, and who exactly is the legal heir, how it is distributed must be known. However, keeping that aside, now that we've understood who's a legal heir, the next step is obtaining the legal heir certificate in Hyderabad. Even this is a big question. We have to first go to the MRO office, that is a Mandal Revenue Office. In Hyderabad, if I'm not wrong, there are 16 MRO offices in Telangana. So we have to obtain an application, fill that application with the details about all the family members who are there, Aadhaar card and other relevant, whatever the form asks for. And once you have submitted, this form is verified by them. It's not a simple case that you have simply given a form and they accept whatever you mention. So they don't do that, and they verify it. And on completion of such verification, the legal heir certificate is issued, in fact, by the Tahsildar. Now, Tahsildar is a person who is the head of this MRO. So they issue this certificate, and once we have the certificate in hand, then we can proceed. Now, this will happen mostly in the next 1 or 2 months. It does not take much time. Earlier, they used to take a lot of time to issue these kind of certificates. Now it has become fairly easier. In fact, the website also mentions that if we go to the MeSeva, there is a website of MeSeva, wherein if you apply there also online, even then your form will be processed and you will be issued such a certificate. However, you will have to obtain the hard copy so that you can use it at various places. Now, next question is, for the purpose of filing the return of income, the deceased for the relevant year under consideration, what all needs to be done? First thing is, of course, register. We have to register ourselves on the income tax portal. That is the most important step. And for the purpose of registration, I have mentioned this I'm sure all the chartered accountants have already gone through. Even I had to go through this painful process, even though I'm not involved in the process of filing returns, but I had to file an appeal before the Commissioner of Income Tax. And that time the client had come and he was like, please do something. And all the chartered accountants were busy at that time. So I had to literally first open the portal wherein they had given me clear instructions of this sort that, first you log on, then you go to the my account, etc. So I followed these steps. They ask you a few details, such as we have to have the legal heir certificate was one of them, wherein they had mentioned that it was mandatory for us to attach. They have also asked the PAN of the deceased, the PAN of the SSE, and such details. In fact, I can show how it looks like, because sometimes that's also important. A lot of people would not have seen it. In fact, how does a death certificate look like? I have a copy of it. I hope everyone is able to see it. I don't know whether
Yes,
people
sir.
are.
Yes, sir. We are
Yeah,
able
the
to.
whole screen is being this thing. Yeah. So this is the death certificate. Now, as you can see, this is in English.
Sir, no, I
We
think
are not able to see the death certificate.
a death certificate we are not able to see. It is stopped at that portal
Yeah.
login iFilling site.
Can everyone see it now?
No,
No, sir,
Shashank, I think you should stop sharing the screen. I think it's not part of this presentation. So stop sharing, show that, and again get back to sharing. Yeah.
Okay.
See, was it part of your PPT, the death certificate?
It's outside on the.
Outside means you have to click on that. No, again.
Okay. Every time I have to share it. Okay.
Yeah.
So now is it visible?
Yes. Now it's.
So this death certificate was obtained by him. He did not know how to do this. So later on, when I told him to obtain one, he obtained one. Okay. After that, however, he obtained it in Telugu. Sorry, the death certificate he obtained, but later when I told him to get the legal heir certificate, he obtained it in Telugu. I tried to upload this, but it was rejected. Because it is mentioned on the income tax web portal that it is mandatory for me to get it in English or the translated copy, because of which I had to again get him to translate it, and he got a translated copy thereafter. Of course, again got a stamp from there, but this was the English translated copy. So this is just for example, so that we understand how they look like. I have to share the screen again, right? PowerPoint. Yeah. So that ways, and once we file a request, sometimes what happens, they deny it, even though you have uploaded everything correctly. Then the only possible way is, again, you try to upload it again, or you try to contact the assessing officer, whoever is your jurisdictional assessing officer, file a letter there stating that you are unable to file it. And if there is any email ID which you can get access to, you can try to file your return or your this thing through that as well. But however, not limited to that. But normally they accept it. They accept you as the legal representative, and then you can file the return on their. You can file the return through your portal. Next. Now, to file the return of income, what we need to understand is, in case of both intestate succession and testamentary, that is, in case where there is a will and where there is no will, in both the cases, the legal representatives only come into play. I'm guessing everyone must have heard of executors, which comes at the time of testamentary succession. That is, when you make a will, we mention that the executor will be taking care of the estate and he is responsible for paying taxes or anything. We don't mention that in clear words, but that is how it is. So, however, till the date of death, when you have to file a return in both intestate as well as testamentary, the legal representatives are responsible. And to compute the taxable income earned by the deceased, the total income earned or accrued till the date of death is considered in the return of income in the name of the deceased. That is the person, the legal representative's name, and then mentioning LR of the legal representative of the deceased name. This is how it is mentioned. So this is how, till the date of death, all the income of the deceased will be taxable and will have to be filed by the legal representative, and no other person will come into play. And who are the legal representatives? We have just understood they will be the legal heirs ultimately. But after the death, they will actually get the estate in their hands. But till the death, he's only in a representative capacity. Even the legal heir will be only in a representative capacity, and that is why he'll be the legal representative representing the deceased and the estate of the deceased. And then he files the return of income. And in case the income, if any, is earned after the date of death, and till after the date of death, whatever income is earned, it will be taxable in the respective legal heirs. If there are 10 legal heirs, all of them will pay tax in their respective returns. How does this happen? Because the vesting of the estate has taken place qua the Hindu Succession Act. The moment the person dies, the estate moves to or goes on to or gets vested into all the legal heirs. Whoever are mentioned in line, as I mentioned, class 1 heirs or class 2 heirs, whoever are there, they all will be taken on record. So they will have to declare income in their own return of income. But till the date of death, the legal representative separately files a return in the name of the deceased. Now, who is the legal representative? Legal representative means this is now again, this legal representative definition has not clearly been mentioned in the Income Tax Act. This, they have borrowed it from the Code of Civil Procedure, which is as per section 211, rule 211, I guess. So as per that, they mention that a person who in law represents the estate of a deceased person and includes any person who intermeddles with the estate of a deceased. So here, simply what they mention is a legal representative can be a legal heir or anyone else, but in a representative capacity. Whoever holds the estate during that time will be considered the legal representative. Now, there's one more question that might come. Now, for the purpose of filing the return, in case there is a belated return, can it be filed? Yes, definitely that can be filed, because as per section 159(3), it clearly mentions that the legal representatives of the deceased shall, for the purposes of this act, be deemed to be the SSE. As per the section, all taxes and liabilities which the deceased had to pay will now have to be paid by the legal representative. Hence, the act will apply mutandis mutandis to in the case of the legal representatives as well. So whatever they had to pay and whatever rights they have to even file a return or a belated return will be available to the legal representative, because they will have all the rights as what were already available till the date of death. That is, as if they were alive. Now, liability to pay taxes as per return from the estate of the deceased. Now, the legal representative needs to pay out of the estate. It's not a personal liability. Whatever he receives as an estate, that is the capital, which is capital in nature, whatever income that they have to show during that year till the date of death will be paid from the estate. It's not a personal liability of the representative, because he's only in a representative capacity for the purpose of representing the deceased. And what the section mentions here is any sum. I have the act in front of me, of course, I could not reproduce everything. What it mentions is any sum which is supposed to be payable. It does not mention any tax. When a person dies, his legal representative shall be liable to pay any sum which the deceased would have been payable. Now, when they say any sum, they include everything. They include your taxes as well as your interest and any other payment that needs to be paid to the government. They will recover it from the estate. But however, it will be limited to the estate. They will not go beyond the estate. If the estate cannot pay, then they cannot recover also. There can be no excess liability that can be fastened on either the legal representatives or the legal heirs in this case. Now, again, one more important point is in case how to apply the provisions. Now, in case the deceased was a senior citizen, let us presume, then whatever the tax rate that would be applicable to him would be applicable to the legal representative as well, for the purpose of filing the return till the date of death. That is the part of the, even if it is 1 month or if it is for 11 months or if it is for the entire 12 months, for whatever he's filing the return, if the date of death is, let us presume, 15th August of 1999. So from 1st April 1999 to 15th August 1999, he will have to file the return. And in that case, if the deceased became a senior citizen or was already a senior citizen during that time, then the rates applicable to the senior citizen will also be applicable here. So however it is applicable, all the benefits, deductions, etc. will be applicable even in this case till the date of death. Now, assessment procedure. Now, what we have done, why have I come to assessment procedure, is because we have come in a line. First, they come to know about the, once they know of the death, they obtain the legal heir certificate, then they upload it on the income tax web portal stating that, yes, now I will be the legal representative. So once the assessing officer becomes aware of the death of the deceased before completion of the assessment, if the assessment has not yet started, that is, it is incumbent on him to bring the legal representative on record before proceeding further in the matter. Now, it is mentioned further, but before even issuing any notice, he has to and must bring the legal representatives on record. And this is not just one legal representative, all the legal representatives on record before they issue any 143.2 notice or a 148 notice. Now, 143.2 is for the scrutiny assessment and 148 is for the reopening of assessment, and both of them are jurisdictional in nature and not procedural. When they are jurisdictional, it is very important. When I'm saying it is jurisdictional, which means that the assessing officer gains jurisdiction by issuing this notice. He gets the jurisdiction to complete the assessment under the set sections by issuing these notices. Anything else, something like a 142.1 is a very procedural in nature. When I'm saying 142.1, it is simply meant to ask for information, and that can be issued at any time, at any time of any proceedings. So that is why, for this purpose, he must bring on record all the legal representatives. If there are two or more, all of them must be taken on record. Now, in a particular case, if the legal representative, if there was a case on this, that is why I'm mentioning that in case a legal representative objects to being proceeded against, like if there's only one legal representative and the assessing officer has issued a notice and then he specifically objects to that, stating that there are more legal representatives, bring all of them on record. But however, if the assessing officer ignores that and continues with the completion of the assessment, then the proceedings would be vitiated, even though one legal representative is on record. But if there is a specific objection with respect to this, then the assessing officer must bring on record all of them. But again, if the legal representative does not raise an objection, let me call him LR instead of saying legal representative so many times. So if the LR does not bring on record, does not object to it and continues with the proceeding or participates and without mentioning that, there are other legal representatives, or he mentions that there are 10 other legal representatives, LRs, but he does not raise the objection that it should not be completed against me. In such a case, the proceedings will not be vitiated if at a later date the legal representative raises such an objection. It will at best be an error which can be rectified, but it will not even be considered as an error because the LR at that point in time when he was participating in the proceedings, he did not take such an objection. But the normal procedure is all LRs must be brought on record. Now, what is the procedure which the assessing officer must follow in the case of assessment on a deceased person? We have a few scenarios here. First one, when a person dies before the issuance of notice under section 142.1 or 148. In fact, here I would like to, I guess there's a correction. It's not 142.1, it is 143.2. Then a notice must be addressed to the legal representatives to initiate the proceedings against the deceased. Now, let me just mention that there could be a few mistakes in the PPT because I've just prepared it before 1.5 hours. So such mistakes, if any, I will keep mentioning them. So yes, when a person dies before the issuance of notice under 143.2 or section 140, the notice must be addressed to the legal representative to initiate the proceedings against the deceased. Now, the current situation is, earlier there used to be notices which used to be served physically. And now what is happening is they simply serve it through email ID, which is also considered as a valid notice. So in case no person has registered as a legal representative of the deceased on the income tax web portal, let's, for example, presume, or maybe there are legal heirs, but they have not actually registered, and the income tax officer or the assessing officer continues to issue notices on the email ID, because now that an email ID exists, it's very simple for them. All they do is simply send a notice on such email ID, and no one ever knows that who has received it, who's opening it, whether the email ID is actually functioning or not. In fact, on this, we had a few writ petitions recently because of 148A, wherein we had filed stating that the person, and it was with respect to not using the email ID at all. So what happens when a person is not using the email ID and we have changed it on the web portal, or we have changed it while filing the return of income but not changed it in the web portal? Such interesting issues come up. There was a Veena Devi Karnani, I remember there was a case law which mentioned that if it is a unused email ID, then such service is bad in law. However, that has been, again, later case laws are there which have taken a different or contrary view. But yeah, not digressing too much. So yeah, in case no person has registered as a legal representative, even though they are legal heirs on they're legal heirs or legal representatives, they have not registered themselves on the web portal, and email ID notices have been issued on the email IDs. So what happens is he will continue to issue such notices till there is, the normal procedure would be, in case no one has responded for a long time, then he should also send a physical notice. It's not, but normally what is the practice is they send notices, they send multiple notices, and then after that they conclude the assessment. But in such a case, of course, the legal representative may take a plea that the notice was never served, and this is a thing of litigation as to, then they will check how did it happen, what are the other steps that the assessing officer could have taken, have we written the correct email ID, why didn't we change, what were we doing, when I'm saying we, I'm talking about the legal representative. So all these questions come into play. It's a battlefield before the High Court if we are filing a writ petition, and it's a battlefield before any other court in case we are going in a normal hierarchy stating that we have never been served the notice at all. So, but however, one thing to be kept in mind is what happens in 148 notices, especially. These people are very smart, because you always had a time limitation of 4 years or 6 years, and they issue it at the end, just before 1 or 2 days. That is 31/3/2021. If that is the deadline for issuance of a notice, they will issue it just exactly 2 days before, and they say that the notice has been served. Now, in case this happens and they have served it on the deceased name, and if later on, let's assume that on 31st March 2021, one scenario, and 1st April 2021, on either of the days, one of the representative, that is one of the legal heirs, mentions that the SSC is already dead, and there must be an issue of notice under section 148 separately on the legal heirs, or the legal heirs must be brought on record. So in such case, in case we have responded later, and now the time limit for issue of notice originally even to the deceased is over, then they cannot issue a fresh notice under section 148 even to the legal representatives. So in such a case, the entire proceedings will be vitiated, and in case they have already passed the assessment order, that is null and void. So then we can go to the High Court directly, trying to quash the proceedings instead of going in the normal course of proceedings by filing an appeal before the CIT, so that you can avoid paying the 20% that falls due, 20% of the demand. So in such cases, when you have a good legal case, we can always go before the High Court directly. So in case the time limit is over, then they cannot again issue, even though there was no mistake of the legal representative, and there is no mistake of the assessing officer also. He was also under the bona fide opinion that yes, he could have issued it. But however, what they do is they wait till the end. That is wrong. So no notice under section 148 or 143 can be issued on legal after the due date or time limitation available under each of these. Now for 148 we have 4 years and 6 years. For 143(2), in case they have issued a notice under section for 143(2), either we have filed the return of income under 139, or we have filed a return in response to 142(1). So from the end of that financial year, we have 3 months. So within that period, he has to issue these notices. So if he does not, then he cannot further issue such a notice, or he cannot assume such jurisdiction to proceed under this section. Now, there was an interesting case law on this. The Delhi High Court had mentioned. Just a second. The Delhi. Let's see what's the Delhi High Court in the case of Vipin Walia, 382 ITR 90. It was mentioned. I'll just read out the relevant part. In fact, this is the relevant part, that is I had mentioned in courts. What was sought to be done by the ITO was to initiate proceedings under 147, what I have just explained. Okay, against the deceased SSC for AY 2008-9. The limitation for issuance of the notice under section 147 or 148 was 31st March 2015. And even in this case, precisely 3 days before, on 27th March 2015, when the notice was issued, the SSC was already dead. If the department intended to proceed under section 147 of the Act, it could have done so prior to 31st March 2015 by issuing a notice to the LRs of the deceased. This is what I've been mentioning, that in case they want to proceed against the LRs also, the time limitation has to be followed. So once the actual timeline within which they can issue a notice has been crossed, then even to the LRs they cannot issue. Beyond that, it could not have been proceeded in the matter even by issuing notice to the LRs. Here I have mentioned that it determines that section 149 determines the time limit for 148 notice, and 143(2) it's 3 months from the end of the financial year. And in fact, this case law was probably one which really caught my attention. What has happened in this case is, like S. Veerappan was one person. He had died, and the wife of Veerappan, she had actually responded to the assessing officer stating that he is expired, so he is no more. You have to issue another notice under section 148. But however, she did not mention as to who are the legal heirs, or she did not completely respond. So here the observations of the court were: the department seeks to justify their stand by contending that they were not intimated about the death of the SSC, that the legal heirs did not take any steps to cancel. This is prior to, okay, till the notices were issued, etc. No steps were ever taken that, you know, to cancel the PAN registration or to intimate the assessing officer separately. All these things which I had earlier mentioned, that the first steps that you have to do is take legal heir certificate and then upload on the income tax web portal as well. All these things were never done. And therefore, the department was justified in directing the petitioner to cooperate in the proceedings pursuant to the impugned notice. A lot of times what the department takes a stand is in case the default is on the LR of not informing the assessing officer, then in that case it's a curable defect under section 292B or 292BB. So it becomes a curable defect because the mistake is on the LR. They should have taken steps to intimate the department with respect to such things. So they say, since it is a curable defect, you cannot simply quash the entire proceedings. So here they say that settled legal principle being that a notice issued in the name of dead person is unenforceable in law. If such a legal position, would the revenue be justified in contending that they, having no knowledge about the death of the SSC, are entitled to plead that the notice is not defective? In my considered view, the answer to the question should be definitely against the revenue. When he's saying, in my considered opinion, the author of the judgment. So this court supports such a conclusion for the following reasons. They've mentioned a few reasons. I'm only reading out what has been highlighted because I felt they are very important for the case. On being intimated about the death, the department sent the notice to the petitioner, his spouse, to participate in the proceedings. This notice was well beyond the period of limitation as it was issued after 31/3/2017. Nothing has been placed before the court by the revenue to show that there was a statutory obligation on the part of the legal representatives of the deceased SSC to immediately intimate the death of the SSC or take steps to cancel the PAN registration. Here, these wordings are very important, because what they say is, under the statute, there is no statutory obligation that they must intimate it to the assessing officer immediately. This is what they mention, but in my opinion, it must be intimated, because at a later date, this will become a debatable issue. And if we go in appeal, we have numerous cases, and this might be diluted. And now, as we see, the stand of the Supreme Court has been changing. So, and mostly against SSC, I would say. So, but however, this particular point they mentioned that nothing has been placed to show that there was an actual statutory obligation on the LR to immediately intimate the death of the SSC or take steps to cancel the PAN registration. All this has not been done, and that is why they had upheld, they had passed it in favor of the SSC. So I felt that was a very important decision which was in support of the SSC. Now, one more aspect I wanted to mention about is what is called participation in the proceedings, because this will again come into question, like when we respond to the notices, will that be called participation? How much of response should be given? So there is one case law of the Gujarat High Court. I did not mention it in the slides. Slides had already exceeded 50 slides, so I had to reduce a little. But Urmila Ben Aniruddha Sinhaji Jadeja case, special civil application number 15310 of 2018, Gujarat High Court. Here they mentioned that all that the writ applicant did was she informed the assessing officer that the notice was issued in the name of her husband. She informed, okay, who was already dead and gone. In our opinion, such intimation to assessing officer cannot be termed as participating in the proceedings. They say simple intimation is also not as not participating. Here they further mention, we could have appreciated this argument canvas on behalf of the revenue if the writ applicant would have filed her return accordingly. If in response to the notice she had actually filed the return instead of saying, or file the return as well as state that he's already dead, but also file the return. If that would have been the position, we could have very well accepted the argument that having participated in the proceedings, such issue could not have been raised. So once he has participated, then they would have said that it's a mere irregularity. They should have mentioned, and hence they would have said that the proceedings are valid. So that case law was quite important. And here there was one question which I had in my mind, which I wanted to, of course, share with all of you, that now we are receiving the 148A notices. I mean, we were receiving, now it has reduced again, but yeah, we have been receiving the 148A notices, which has been challenged in writs also. But what will be the situation in case a 148A notice is issued on the dead person? And during that time, we have either responded and mentioned that, there could be again two scenarios, that we have mentioned that the legal heirs must be brought on record, or secondly, we have not mentioned anything and he has completed and he has passed the order under section 148A(d). There's a formal order that he has to pass stating that he has reason to believe that 148 notice can be issued. So in case a 148A(d) order is passed in the name of the deceased instead of the LR, even though we have mentioned or we have not mentioned, now will that be curable in nature? One thing we need to understand is only procedural provisions can be curable, but not jurisdictional provisions. Now, when I'm saying jurisdictional, where the assessing officer is able to get the jurisdiction by issuing any notice under such a section, and such sections are 143(2) or 148. Now, 148A has been brought in so that they can make preliminary inquiries before assuming the jurisdiction. So hence, I would consider this as a procedural section. And hence, I would say that, yes, it will be curable. But however, again, one more question comes here is, in case 148A(d) order is passed, and I'm assuming that most of us have already seen how the notice looks, how the order looks, the 148A(d) order. This 148A(d) order, it Just a second. The 148A(d) order has it has a last line which mentions that, in view of the above satisfaction, we are also issuing the notice under section 148, and immediately on the same date, whether you get it physically or not, but the same date will be mentioned as that of 148A(d), and a 148 notice is also issued. In such a case, will that be curable or not? Because again, 148 notice is to assume jurisdiction. So in case by this time and later on this he has not rectified that issue and your time limit goes away, so again we fall back on the earlier provisions, as we already see, that in case there is no time limit, then they cannot issue a fresh notice under section 148 to the LRs. But however, if they have the time limit, they will simply rectify it and they will issue a notice to the LRs as well after bringing them on record. So now scenario 2, what happens in case the SSC dies during the assessment proceedings? That is where proceedings for assessment have been commenced by the issue of notice, but the assessment has not been completed. That is, I'm saying he's already assumed the jurisdiction. That is, he's already issued the notice under section 148 to the SSC. Now, who is the SSC? I'm not talking about the legal representative. I'm talking about the deceased. And if he had filed his own return, and then after that the assessment proceedings were also initiated, but before he could respond further, he had expired, then what is the situation? Just a second. Yeah. Then what is the situation? So in such a case, the same proceedings will be continued against the legal representative as well. And by virtue of section 159(2), the proceedings would have been deemed to have been started against the legal representative, and it will be continued against the legal representatives. And they should, at best, the fresh notices under section 142(1) may be issued for procuring further information, and accordingly, they must proceed with the proceedings. Whatever questions they ask, we have to provide whatever is in our possession, the information. Now, a scenario 3 again, where proceedings for assessment have been completed and notice of demand has also been served. That is, the SSC was existing at this time and the order was passed in the deceased SSC's name, and even the notice of demand was also served. Then in that case, the legal representative will again, they come into the picture, and they have to file the appeal before the Commissioner Appeals, or whatever, take necessary actions if they have to file a writ petition. But those proceedings will not be vitiated just because they have been passed in the name of a person who is now no more existing. So it will not be a case wherein again they'll have to be referred back or something. Once the assessment order is passed, it is final. So now the legal representatives will have to take this further. Now, one more thing I wanted to mention is 142(1), the notices do not have a time limit, and hence whether it is issued during the lifetime of the deceased or it is issued at the first time to the legal representative, there is no bar on the assessing officer to issue a fresh notice under section 142(1). Unlike the rest of the provision 148, everything has some time limit, but when you see the act, 142(1) does not have a particular time limit, because it's merely to gather information. There is no particular limitation on this, whether and when he should issue, or till what time he can issue the notice under section 142(1). A few other relevant aspects in this under section 159, that in case firstly, all the legal representatives must be brought on record, as I guess I've already covered this topic, but yeah, all of them must be taken on record. And however, if only one legal representative have been served, then even if one has been served and he does not raise an objection, this I've already covered this, then it will only be considered as an irregularity, which may result in setting aside of the assessment and not its complete cancellation. And but however, again, if he objects to it, then definitely it's not a mere irregularity and the entire proceedings will be vitiated. Now, and if the notices are served on the legal representatives which have any mistakes, probably mistakes of name or mistakes of addresses or any such simple mistakes, it will not be any jurisdictional defect. It will simply be, it is a rectifiable defect. So a lot of times, this is the only argument that the department takes, that, it's only an irregularity and section 292 comes into play and it can be rectified. But we need to understand where as per law it is allowed and where as per law it is not allowed. And again, if any one legal representative decides to give, decides to represent, then the other legal representatives can also provide a letter or sign on a paper stating that this one person can represent on all our behalf. But however, and accordingly, he will take forward the proceedings. Now, if the assessment is complete, then what about the penalty and recovery proceedings? They all will be continued against the legal representatives, and if they were existing at the time of the deceased also, they will simply be continued against them. And if they were not existing and they have to be now initiated, they will be initiated at this time. Ultimately, what the problem was of initiation was the assumption of jurisdiction under 143(2) and 148. But however, penalty proceedings, all these, they come after the completion of the assessment proceedings, and once they are completed, irrespective of the deceased, irrespective of the SSC being alive or not, they will be initiated. If he's alive, on them, and if he's not alive, on the legal representatives. And the amounts also can be recovered to the extent of the state. Again, we need to understand that ultimately legal representatives are only representing the deceased. So only to the extent of the state he will be they will be liable to pay. Now again, prosecution cannot be initiated, and certainly so, most logically so, because for whatever act he has done, any other person cannot be held liable. And even in case of penalty or any other amount, no other person is being held liable. The estate is held being liable, and you can never prosecute the estate. So all you can do is recover from the estate, and hence there are no prosecution proceedings which can be initiated against the legal representative for any of the offenses. There we were talking about intestate succession. Now, what is a testamentary succession? Is it covered under 159? No, it has to come under section 168, wherein. And one more thing I forgot to mention. Now, whether there will be a personal liability on the legal heirs, there will not be any personal liability on the legal heirs, unless, because during that time, if they are, if they try to sell away the estate or they do not try to pay the taxes, then they will be personally liable. Otherwise, personal liability on them does not arise. And a few other points that we should inform the banks also. I've already mentioned this. In case of a death, immediate information must be also provided to the banks or any such institutions, so that they can change, and simply the amount does not fall into the account of the deceased and they are lying there. So once we inform them and we mention that we are the legal representatives, then such amounts will be transferred to us. So, and in whose span the TDS must be deducted, all those can be taken care of by the bank or any other institution. So we have to be the one informing them by way of a letter, and with the, of course, supporting documents as to how you are related or how you are the legal representative. Next. Now, coming to testamentary succession. Now, assessment under this section commences from the date of death and ends till the complete distribution of the estate of the deceased. Even though there is a testamentary succession, till the date of death, a legal representative must be brought on record. But it's after the date of death who comes into play, who is the person responsible. Will it be the legal representative? My answer will be no. If everyone were thinking the answer was yes, no. Legal representative till the date of death. After the date of death, in case of intestate, it vests in the legal heirs. In whatever proportion, in that equal proportion, all of them will have to pay taxes by showing it in their own personal returns. But however, in case of a testamentary succession, that is, in case a will has been provided stating that XYZ person will get my estate, and there is also, it also mentions executor, and that person signs. If you see the format of a will, you see that several persons have signed, and there will be a mention of executor where they will mention, where they will sign, and such executor is the person who manages the estate of the deceased or the testator. The deceased will also be called a testator when he writes a will. So they manage this the estate of the deceased till the complete distribution of the estate. Now, when I'm saying complete distribution, what happens is a lot of times in the will, mostly what happens is one of the spouses die, and if they have all the property in their name, they mention that till the survival of my spouse, these properties can only be enjoyed by the rest of them, and only after the death of my spouse or whoever it is, of XYZ person, will this property or will this estate devolve upon the rest of the people or devolve upon the persons mentioned in the will. So in such cases, what happens is the rights in the estate, the rights in the properties do not directly vest at the time of death, as we see in the intestate succession. So the executor will have to wait till that uncertain period. Of course, it is certain in all rights, because once we are saying death of some person, it is certain. We just don't know the time period, that's all. So be it 5 years or 10 years, till that time, an executor will be managing the estate, will be filing returns for the estate on behalf of the estate of the deceased till that time. And even this return is divided into two. One, he files it on behalf of the deceased, and one is in his personal capacity. So till all the properties are distributed completely. And there's one more aspect which sometimes in the estate they mention that XYZ get a particular part of the property, and whatever is the rest of the best goes to so and so. Or if they don't mention anything, what if there are a part of it is a will, a part of it is not a will? So in that case, a part of it will be considered under the Hindu Succession Act. That is, all those people immediately those assets will vest. But again, if they keep a condition or clause saying that, whatever are the assets again till the life of my spouse, etc. So in that case, executor will have to be there and wait and file returns and take up responsibility till the date of distribution of all the assets. Now, who's an executor or administrator? See, we use all these terms very loosely. Executor, okay, I understood that he has to sign on the will. Who's an administrator? Must be the person who is administering the property. So, however, everything has been given a particular definition under the Act. Now, an executor is a person who is appointed by the testator to carry out and execute his wishes for that purpose, to administer his estate after his death. So that is clearly it's mentioned that it's a executor. But what happens if they don't mention? If they don't mention about an executor, in such a case, an administrator will come into play, and this administrator comes by the order of court, because the court orders the court grants letters of administration to administer the estate of the deceased. And this happens because the beneficiaries, whoever are the beneficiaries mentioned in the will, they approach the court so that one particular person to administer the estate can be appointed. So it happens when there is no mention of the this one. So that is how there is a subtle difference between estater and administrator. But however, they do the same job of managing the estate till all the properties or till the execution of the same. Okay. Now, yeah. Now, assessment in the hands of legal representatives and executors or administrators. As I've already mentioned, I've explained this, that the responsibility of the legal representative is limited to the year of death only. Only in the year of death, your legal representative comes into play, that too till the date of death. After that, in case of intestate succession, it goes to the legal heirs, and in case there are executors or administrators that is under a will, then they will be taking care, they will be filing the return. But before the date of death, it's the legal representative who will be responsible. So this is how it will be divided, and two assessments will take place in such case. That is, two returns will be filed, two assessments will take place, one till the date of death and one separately. Yeah. After that, separate assessments. As I already mentioned that the income from the estate of the deceased shall be assessed separately, and the income of the executor or administrator shall be assessed separately in their personal capacity. So they both cannot be merged. Unlike in case of legal heirs, as we see, the moment it vests in them, they start showing it in their own income. And the reason for that is because they are now the owners of the property. The moment it vests, when I'm saying vesting means getting a right, getting a legal title over such property, and once they do that, they show it in their own personal returns. But however, in case of an executor, executor or administrator, he merely acts in the representative capacity. So there has to be separate assessments separately for the estate of the deceased, and separately in his own personal capacity, whatever is his income. And there will be carry forward of losses also in case, since the assessment on the executor is continuation of assessment on the deceased, the losses of earlier years carried forward in the hands of the deceased can be set off against the income of the estate. Again, understand, it's only in the income of the estate, that is the return that he is filing for the purpose of declaring income on the estate for the subsequent years. Only against that income this will be set off. And what are the number of years that will be available? Number of years will be whatever are available, whatever are left will be the number of years. If the carry forward losses in the hands of the deceased was already around 3 to 4 years, then what will be available, or what will be carried forward in the hands of executor will be the rest of the 4 years or 3 years, whatever, 8 years in case of business losses. Again, a few more noteworthy mentions. The thing is, this there was too much information, so I could not really put everything on the PPT. And as you can already see, the quality of PPT, which is simply white background and with copy paste this ones, I could not do much. So
the content is more important, sir.
I mean, I tried to put in more content. In fact, if I have to share the PPT, I will add the rest of the content after the this one, and I can share it for the benefit of others. So notice of the service I have not mentioned, who ultimately the so the executor, in case he mentions executor will also have to inform, similar to the legal representative, where even an executor will have to inform the assessing officer with respect to him being the executor. Only then the executor will be served notices. And in case there are multiple executors, what happens? Then they form an association of persons, and they will be filing return as an association of persons. Normally what happens, only one executor is there in the will, but in case they mention in the will that there are multiple, there are 5 to 6 executors, 2, 3, 4, whatever it is, then they have to fall under the bracket of association of persons. So they have to particularly mention to the assessing officer that now they should be receiving all the notices, and they are responsible for managing the estate of the deceased. What will be the residential status in this case? And in fact, in case of the legal representative, I forgot to mention this. In case of the legal representative, the residential status will, because he is only filing till the date of death, whatever was applicable to the deceased will be applicable to the legal representative. Even in case of executor, whatever was applicable to the deceased will be applicable in the case of the executor. The reason is there are two different returns. Executor is on behalf of the estate, that is why, not in his personal capacity, only for the purpose of computing the income on the estate of the deceased. Whatever income you are receiving on the estate will be the capital assets, and the income will be whatever income you are earning on that. So for that purpose, the residential status will be what was applicable to the deceased. Next, defunct entity. Now, normally what happens is an entity or a company, if it is not carrying on any business, let's say for a consecutive period of 2 years or more, I've just mentioned 2 years, but any number of years, but they have completely halted their business, or they're not at all continuing with their business. So in such a case, it will be termed as a defunct entity or company. Now, defunct company is also a terminology used under the Companies Act. And whenever it is a defunct company, the registrar, it can be struck off from the rolls of the registrar of companies. However, that is also not mandatory. Either an application can be made by the company itself, or the registrar can, based on whatever the circumstances around it, they can also strike it off. In this, there was a case law with respect to the defunct entities only. Before that, I would also like to mention that the defunct company, the expression of defunct company for the is under section 560 of the Companies Act, which means a company which is not operating or functioning, not carrying on any business, or is not in operation. And it is generally understood or visible from the available balance sheet of a company. So, and in case the company's name is sought to be struck off, a notice, before it is struck off, a notice must be sent to all the people who are interested. Now, when I'm saying interested, they could be creditors also, but a notice is also sent to the income tax authorities before the name is struck off, stating that we are striking off, are there any liabilities pending to be this thing. So, however, in this case, the Supreme Court, in the case of Gopal Shree Scripts Private Limited, in this, what has happened is the High Court had taken a different view. It was brought to the notice that the name of the company, name of the company has been struck off from the Register of Companies. So High Court was of the view that since the company stands dissolved, as a result, the order passed by the Register of Companies under 560, the appeal filed against such company which stands dissolved do not survive for its consideration on merits at all. But however, the Supreme Court mentions that they cannot accept such view. They mention that the High Court failed to notice section 506(5) proviso A of the Companies Act, and further failed to notice chapter 15 of the Income Tax Act, which deals with liability in special cases, and its clause L, which deals with discontinuance of business or dissolution. So the aforementioned two provisions, namely one under Companies Act and the other on the Income Tax Act, specifically deal with cases of the companies whose name has been struck off under 506(5) of the Companies Act. And accordingly, of course, in this case, no one had appeared in the case, but however, the Supreme Court had taken a stand and it had dismissed the order. It has struck down the order of the High Court, stating that it under the Income Tax Act, these particular provisions are discontinuance of business deals with such defunct entities. And where does this come? This comes under section 176 of the Income Tax Act, if we have ever seen that. As per section 176, the heading of it mentions, let me just read it out. I have not mentioned the heading of it there, but this the chapter L says discontinuance of business or dissolution, and section 176 specifically deals about discontinued business. So discontinuation or cessation of a business of an SSC, where the business is no longer in existence. When I'm saying no longer in existence, they do not wish to continue it at all. Discontinuance cannot be, and it can be either of the business or profession of any person. So all the operations are completely halted, not with a view to simply again restart it after a year. Your intention is quite important here, that complete discontinuance is there. Something like, for example, if a lawyer he wants to if he makes an application to become a judge, so in that case he cannot presume that yes, after so and so date I will again go start practicing, or after 5 years I will retire from judgeship and then again practice. So in such cases, that will be considered as a discontinuance of profession, so complete discontinuance. So in such case, so section 76 deals with such cases. Now, what is the manner of assessment in case of business which is discontinued? Yeah. Now, where any business or profession is discontinued in any assessment year, the income from the period of expiry of the previous year for that assessment year up to the date of such discontinuance it can be assessed at the discretion of the assessing officer. It can be assessed to tax in that particular assessment year also. Now, this is called accelerated assessment, but however, if he chooses not to, because it's not a mandatory thing to actually do this in that particular assessment year, the assessing officer can wait till the proper assessment year and then continue with it. But however, he has a discretion that in that particular year itself, he can choose to make it a part of the year, that is till the date of discontinuance, or take the whole of the year and make this accelerated assessment. May choose to do it or wait till the completion of the assessment year and then make the assessment in accordance with the normal procedure. Now, the total income of each complete previous year or part of previous included in such period shall be chargeable to tax at the rate or rates in force in that assessment year. In separate assessment shall be made in respect of each completed previous year or part of any previous year. So this is an option of accelerated assessment which he may choose either during that assessment year itself or at a later time taking the normal course of procedure. Now, even regular assessment can be completed in this case. It's one more thing I wanted to mention, that this above process of making accelerated assessment can be done in case an SSE is having multiple businesses and he only discontinues one or two. So even in such cases, only in respect of those one or two, such assessments can be made. No, sorry. Regular assessment can be done on SSE even after completion of accelerated assessment. That is, in case an assessment has already been completed, even all the other provisions also of the Act will apply equally, and an accelerated assessment will not bar it from making the regular assessment in the case of such discontinued business in the hands of the SSE who was running it at that time. Now, what is the, I have not mentioned, what is the time limit for filing the return of income? In case of an accelerated assessment, what happens is they issue a notice immediately. The assessing officer will issue a notice under 142(1) for making a regular assessment, or under section 148 for making an escaped assessment, and they may require furnishing returns. So as per whatever they mention, if they mention 7 days or 10 days, whatever it is, as per that we'll have to file the return for that particular assessment year. Now, what is the responsibility of the person who discontinues their business or profession? Now, how will the assessing officer know that we have actually discontinued our business? So for this purpose, subsection 3 mentions of 176 that whoever is discontinuing the business or profession should give the assessing officer notice of discontinuance within 15 days thereof. Within 15 days, he must intimate intimate the assessing officer that yes, this has been discontinued. And in case there is a failure, in fact, they have also levied a penalty under section 272A, that is 500 rupees per day of default. Of course, everything is condonable in case we are able to explain the reason as to why you were not able to inform or intimate the SSC, that can be deleted. I mean, such a penalty can be deleted. However, that is subject to the discretion of the assessing officer, as well as what are the reasons that we are mentioning. If they are unreasonable, of course, they will not accept it. So, but however, for the time being, as per the provisions, there will be a penalty in case the SSC discontinuing the business does not inform the assessing officer of the same. Now, one more thing I forgot to mention it in the slides is section 176 subclause 3A of the income tax. That provides that any sum which is received after the discontinuance of business, till the discontinuance of business, it will be assessed as business income there. But however, after the discontinuance of business, it is to be regarded as income of the recipient in the year of receipt. Now, if the SSC is receiving it as receiving it in any subsequent year, then it must be taken as a receipt for that person, as if it would have been included in the total income of the person who carried on business had it been received before such discontinuance. Now, next point is about discontinued profession, which is 176 subsection 4. The same section talks about both business as well as profession. Now, profession also, the same understanding comes that when you are saying the intention must be that it's not of any temporary pause, but ultimately when you are thinking of discontinuing, it's of a permanent nature. Here, one difficulty that could arise is with respect to a cash basis. In case a person is following a cash basis, and normally lawyers, if I'm given to understand, they follow cash basis. CAs also I've seen. CAs I do not know, but as a lawyer, a lot of them follow cash basis of accounting. And the reason for that is, even though we fight the cases, by the time we receive the fees in that, it takes a long time. So hence we choose cash basis of accounting. So in such a case, in case a person discontinues their profession and they have received the income after a long time, maybe after next year, next to next year, or after 10 years, someone gets up and they're like, oh, thank you, I'm very thankful that you had actually argued my case and I feel guilty about it. And they come to me, let's assume that I am discontinuing my profession. They come to me and give me 10 lakhs or 10,000. Let me not disclose too much. So let's assume he's giving me my fees of 5,000 rupees. So in such a case, it must be treated as an income that has been held by court in my hands, but it will not be treated as professional income. And that is why a dispute had come up with respect to the head of income. Under which head should it be considered? Should it be considered under income from profession, or should it be considered under income from other sources, or should it not be considered as an income at all? In fact, I had gone through the what is this called, commentary. In that there is a small mention of this, wherein he mentions that it should not be considered as an income at all, because once it cannot be considered as income under profession, it cannot be considered as an income under other sources. It becomes a capital receipt. It becomes of capital in nature, and once it is a capital receipt, unless it is specifically taxed, it cannot be taxed in my hands if there is no provision for that. So he leaves it at that, of course, that that could be one of the interpretations, but subject to the discretion of the courts. Now, however, the courts have, there are numerous judgments on this, and a few of them mention that, yes, it must be taxed, but however, the issue was with respect to under what head. Now, there was one case with respect to this, Datta Justice, 1989, 180 ITR 86, wherein it was held that profits and gains of a business or profession received in subsequent year after discontinuance of profession cannot be taxed under section 28 or 56 or 76. So judgment was peculiar, that's why I had mentioned it, but there are case laws which say otherwise. Because on the plain reading of the section, it clearly mentions that if any sum is received after the discontinuance, it shall be deemed to be the income of the recipient and charged to tax accordingly in the year of receipt. Now, if such sum would have been included in the total income of the aforesaid person, had it been received before the discontinuance, this is a verbatim of the section. It clearly mentions that had it been, it should be treated in the same way as it would have been treated in the hands of the deceased. But there is one case law, I'm unable to recollect the name, which mentions that it should be, it definitely has to be an income. It cannot be an income under business or profession. It has to be an income under other sources. So there could be disputes with respect to that as to how exactly we should treat it. But yes, discontinued business or profession at a later date has to be taxed in the hands of the person receiving it. So with this, I would like to end, because I have broadly covered all the aspects, but the next aspects which I would have to cover is with respect to liquidation and companies and the liability of directors and partners. And I feel probably a separate session for that would be relevant and important, so that we can go in depth in that with case laws. So for the time being, I would end it here, because this gives us a broad understanding of the steps to be taken right from the start. What is the first step to be taken? And after that, first step with respect to how to obtain the legal heir certificate, who are legal heirs, who are the legal representatives. Right from there, I've tried to come. But I'm sure that I could not have covered the entire thesis on this, entire subject on it. So I hope if there are any questions, I'll be able to answer, or if there are questions that people could mail, we could always give answers to that. Over to you, sir.
Thank you, Shashank. I think if you stop sharing the screen, we can.
Technology is playing games with me also, sir. Yes.
Everybody.
Yes.
Yeah.
I guess I got it. Yeah. Yes, sir.
Ravi Shankar, can I ask a few questions?
Please, sir. Please, it's your session.
I think you have covered quite elaborately this topic. Always there is a scope for dispute and doubt. Here there are two issues here. Now, even in case of testamentary succession, at least in this part, like in Hyderabad, what I have seen is in wills they don't mention an executor. They only say that my property will go to this, will go to this, will go to so and so. But they forget to mention or they don't mention the executor because fairly they are simple wills or whatever it is. But what people write in Mumbai and other places, I have seen that they invariably do mention about executors. Now, suppose if executors are not mentioned, then what would the position stand as? And my second question is, now where do I draw a line that the estate cannot pay?
So firstly, in case there is no executor, then they have the beneficiaries. Beneficiaries, when I'm saying the persons referred to in the will have to approach the court. It has to come from the order of a court, wherein that will issue a letter of, I'm forgetting the name, but I have mentioned it in my listing. So they mentioned that one of them will be an executor to handle the estate. So it is an order from the court, and it is by the application of the beneficiaries that we get that. And where is the limit? There is no limit, sir. Until and unless the entire estate is gone, they will recover the tax if tax is there. So, and priority for the government is to recover tax. So the first thing that has to be paid out of is the tax amount. And of course, as per in fact Companies Act, it mentions that when there is recovery, the first persons in priority will be the secured creditors.
Yeah.
So, but however, in our case, how would you prove that someone is a secured creditor? And since provisions of Companies Act do not apply to us, normally the claims of the government will have a priority. So,
and the problem is most of the SSCs or even most of us, we are not very well conversant with this issue. So there have been huge demands raised. There are various scenarios that you have discussed: participated, not participated, or they responded, they filed a return. Now, in one case, the daughter has filed a return as an LR. The lady already passed away. She filed return in capacity of LR. Then an assessment was made under invoking section 50C. And now the issue is that there is no estate.
Okay.
So that property was sold during the lifetime, but subsequent. So in this case, now the daughter has to pay invariably, or is there any scope for her to wriggle out of the situation, because we are trying to protect the interests of the client?
I mean, once you are saying that there is no estate at all, so this fact needs to be brought forward before the authorities, mentioning that, you know, even though if there is a tax demand that is raised, ultimately they will pass the order. That we cannot stop by saying that, you know, just because deceased is not there and a legal representative, I cannot explain, or there is no estate, you should not pass the order. But at the time of recovery, probably we can mention this, and if they don't take any action, again approach the High Court in writ jurisdiction to help us out.
Now, what if that lady is like a rich lady? Like suppose the hair is well off. Then can she still take a stand that the estate is not there? So I have participated in the proceedings. I have filed a return and all. It is only in my capacity as LR, and hence I cannot be asked to cough up the tax due to
As
my.
long as the property of that LR is their self acquired and it does not come from the estate of the deceased, they can always take this stand. Because the section is very clear about it, about the extent to which this estate will be liable, like extent to which the LR would be liable. And it's only to the extent of the estate. That has been very clearly mentioned, and hence they cannot go beyond it.
Thank you, Shashank. And one more thing, in case of company.
Ramdev, sir,
Sir, I think Ramdev sir has
has
raised his
been-
hand.
Yeah.
Sir, you have made as a panelist, sir. Please speak, sir.
Can I?
Yes, sir. Please go ahead, sir.
We can't see you.
If Bhanu exhausted, then I will proceed.
Sir, one more question is there, sir, but it will wait because you are my bade bhai. So first, you pehle aap.
Thank you, Bhanu, for that kind and generous response. Just Shashank, I would like to know,
Yes, sir.
in case of a deceased person whose will is not yet executed,
Yes.
for how long? Is there any limitation period for filing return in the name of the deceased by the LR?
Sir, what happens is if there is, you're saying there is a will, but there is no executor. Am I right?
Not yet executed, not yet
Not
executed,
yet, okay, so there is an executor, but not yet executed.
not yet executed.
So what happens, sir? The will can be of various kinds. Sometimes the will says that, if they have 10 properties, 5 properties go to my son. The rest of the 5 properties will go to my daughter. And if there are 2 more properties, they will go to my daughter and son after the lifetime of my spouse. Let's assume that these 3 aspects are there. To the extent of the properties which are mentioned that it will go to my son or daughter, they vest in their hands immediately, because the will states so that immediately after the death it will vest in the hands of the son or daughter. In that case, they will be responsible to pay, and they will include the income on the estate by including it in the return. But however, for the rest of the 2 properties, that will have to wait, and the executor will have to bear responsibility of it till such date whenever such situation takes place. That in case they say the life of the spouse, till the lifetime of the spouse, they'll have to wait. And mostly the wills will not have any clause which is impossible to perform. Something like, tomorrow when there is a blue moon, at that time all my properties should devolve. So that such a will normally you'll never see it in existence. So there will be a certainty in the will, and till that time executor will be responsible. There are cases wherein for 8 years, 9 years, the executors have been filing returns for the estate of the deceased.
Here, one small latch is there, Shashank.
Yes, sir.
That latch is with respect to distribution of the estate. Unless and until that executor distributes, how can the beneficiaries know that they got this share and they can show their income, that income in their hands?
Sir, when they say about distribute, it does not literally mean that he has to go catch them and mutate the properties on their name. Once the will states, so it's similar to the Hindu Succession Act wherein it is intestate. Even soon after the death, it will immediately vest in the hands of the legal heirs. It's not a case where they have actually gone, applied and got the properties mutated in their names, got the property documents. All this does not literally in physical format happen. But however, if the courts have taken any different view, that we'll have to do a research upon. But but normally when they say that, till it is distributed, it means this, that, once it vests in someone, till that time.
Okay.
Hello.
Thank you.
Sir, we'll discuss about this again, sir, on phone call.
Sure.
Probably we can have more insights into the facts of the case. So how
Yes,
exactly he did not distribute is a question.
No. Actually, issue is that I couldn't remember exact cases. Some cases I have read that the deceased person's returns have to be filed as long as that estate distribution is completed.
Correct.
And that responsibility in the will deed is bestowed on the executor.
Correct.
And unless and until that executor performs the duty of bestowing that asset to the beneficiaries,
Correct.
how can beneficiary know that this estate or this part of the property belongs to me and whatever income is there is known to me? Like this, it has become a sort of taxation planning tool in many cases.
One thing, the legal heirs, or normally what happens is they give it to the same legal heirs in the sense the immediate kith and kin or their family. So soon after the death, their first question would be this, that, what has happened, unless he's by will giving it to a third party. So then probably they will not know until the actual distribution. The executor will have to take up the responsibility. But otherwise, questions will be raised with respect to what has happened with the properties. So
Well, primarily that executor must come forward.
correct. Executor has to come forward in case no other person has knowledge.
He should fix a date and issue notice to all the beneficiaries as per the will at a one place or separately. He can inform them as per this will, and a copy of the will. Because for immovable property, I think the will should be registered. Sir,
will, it's not mandatory for a will to be registered.
No, it is not mandatory. If it is registered, then transfer would be easy.
Correct. If it's registered, transfer would be easy. Otherwise, you have to go for a probate, that is, get an order from the magistrate. You approach the magistrate, and magistrate will decide who are the legal heirs, or not who are the legal heirs, as per the will, that whether it is a good will or a bad will. Literally, the terms are good will or bad will. Good will means what they do in a probate is they issue notices stating that are there any other person who has to claim or who has to dispute the will, and they also issue a notice in the newspaper. So after that, they decide this and they certify that this will is a good will. So it's similar to registration, or it's a more secure process. You don't need to go through all this.
Probate and all is
here one small thing, Shashank.
Yes, sir.
If that unregistered will was used as evidence of owner in any litigation, whether with the tenants or somebody else, even after that, how can they say that probate is required? Or because in the court they have accepted that these are the legal heirs are valid owners. Automatically, when courts admitting that, in context of some other cases, like cases with the eviction with the tenants, so that will mandates that it is a good will, as long as that will is not questioned.
Correct. In the course of some proceeding, if the court has itself mentioned it's as good as probating it, but normally there's a particular procedure for it. But if the court in some other exceptional circumstances in some proceeding, it mentions that they are the actual legal heirs and giving the reasons thereof, then that should be sufficient to take it as an evidence in other places.
Yes, that was my thing. Thank you, Shashank.
Thank you.
Now, our Bhanu Narayan is having a lot of doubts, so please satisfy him.
I recognize the presence of our past chairman, Machar Rao sir, and senior members.
Past Central Council member, SSR Koteshwar Rao sir also.
Past Central Council member, SSR Koteshwar Rao sir.
Hello, sir.
Sir, Machar Rao sir, Koteshwar Rao sir, you want to add something?
Good evening to all. Really appreciate the efforts of managing committee for organizing a wonderful session today. Shashank ji, a beautiful concept. We as a practitioners having a lot of doubts in this area, and thanks for clarifying this. Practical approach.
Even as lawyers, we have a lot of questions, because ultimately where I specialize is under income tax law. So these kind of questions are even new to us. Like, we may have read it once, but the procedural aspects of it, a lot of people do not know. Even for me to now go to the MRO office, I will be loosely used, dumbstruck. Ultimately, I have to depend on those clerks there. They will know the law better than us.
Machar Rao sir is also a lawyer, sir.
Nice.
Yeah, Shashank.
Yes,
Sir, Koteshwar Rao garu. Sir.
Bhanu sir.
Past Central Council member is there, sir. Sir, Koteshwar Rao sir.
Sir,
please guide us, sir.
No, I should thank Mr. Shashank for giving a beautiful exposition on this subject.
Thank you, sir. Hello.
Now, Bhanu sir.
So many senior members have joined today, sir. Those who are facing the real challenges on the law, practicable and implicability.
So if senior members have joined, I guess they can clarify a lot of doubts, even of mine.
Shashank, one question is
Yes, sir.
that if I remember correctly, the will need not be probated
Will
or
not be registered.
registered. Even probate is not required only in other than Bombay, Delhi, Calcutta, and Madras, which are the presidential cities,
Correct.
presidential towns. But now it has become almost everybody is asking for registration of. Of course, it is a slightly out of today's context, like it is somewhat a subsidiary or a supplementary question. So, what is the reason that they are asking for mandatory registration of wills, whether the act has been amended or is it for convenience sake that this registration is being demanded?
Sir, Act has not been amended to say that it is mandatory, but it's only that it will have a better evidentiary value. Ultimately, sir, what happens, why they have not kept it mandatory for a will is, of course, the circumstances may be very less, but when a person is writing their will, it could be on their deathbed as well. And at that time, you cannot expect that person to go and get the will registered or be present before the registering authority. That is the reason they have never kept this mandatory, and they cannot keep it as mandatory. But however, for safeguarding the interests of the persons who are mentioned in the will, or safeguarding the interests of the wishes of the deceased, they have mentioned that it's better to get it registered if you are writing it beforehand, or at least get it probated so that you have the decree of the court, so that it will have some evidentiary value. Ultimately, it has evidentiary value, but anyone can challenge it. To avoid that challenge in the future, we go through all this. But even today, if you do not get it registered or probated and carry that will around, it will not have any problem. Even after 5 years, you can get it probated in case you need it for some reason, but it still stands valid. But however, questions may come at the time of probation. A court may ask a question: why didn't you get this probated beforehand? What happened? What resisted you? Is it a created document? A lot of time, because of the property disputes, is what all these come up.
Yeah, Birla's will, that case. Chairman, can I ask one last question from my side?
I do have a few questions. Please go ahead, sir, then I'll ask.
Shashank, now regarding the non-corporate assessees, it is more or less clear. You have given a very clear presentation. Whereas as far as the directors, the liabilities of the directors of a defunct company, now normally it is a limited liability, but also the Income Tax Act has a prosecution clause under 278B. So the interplay between these, or vis-a-vis these two sections, what could be the liability of a director of a defunct company when a default was committed, especially with regard to TDS, collection of TDS and non-paying of TDS to the government?
In fact, the liability of directors, there's a particular section on this, that is
278B, capital B.
178, if I'm not wrong.
178.
178, company of liquidation, that is liability of directors is also mentioned, wherein I remember reading that, if unless they're able to mention that, they were not responsible for whatever default is there, they would be responsible, they would be liable. But if they are able to mention to the assessing officer that, they didn't have a role to play, or because they were not negligent because of which such a default had taken place, then they would not be liable. So I'm forgetting the section, of course.
278 capital B.
No, sir. In 171, I remember seeing it in 170s.
Yeah. 278 is prosecution. Maybe 178. Yeah.
I guess it is 179, liability of directors of private company.
Yeah.
Section 179.
Yes,
there
sir.
It mentions that, every person.
They are all for existing companies which are operational.
Correct.
Defunct companies. So.
Acha. Defunct companies, even I'll have to look into that particular aspect of what happens after, because normally what happens, a company being defunct, At that time itself, they send the notices to the assessing officer, and the liquidator, if any, will be paying off all the debts at that time. So the liability on the directors later on, I don't see it coming up, but I'll have to look into that once. So we'll discuss that, sir, once after this one. I'll also
Yeah.
look into it.
Shashankji, small question here.
Yes, sir.
Yeah, merely strike off by the MCA is not escape from the liabilities, no? Because you are saying one Companies Act provision and one Income Tax Act provision. For example, one of my company is there. There is a lot of issues are there.
Yes.
MCA already strike up that company. My liability still is there, no? Simply we cannot
Yes, it will still be there.
saying that is not there.
No. The liability will still be there. In fact, the case law mentions that the liability will still be there under the provisions of income tax, even though it has simply been struck off. Off from the rules of Register of Companies, the liability still is there. In fact, as per Section 560, what it mentions is striking off per se does not mention that the company ceases to exist. They can also be revived later on by another application. So it's not a complete liquidation. So
then directors are still liable.
Sorry.
Directors are still liable, no?
The directors, yes, they should be liable, in my opinion.
Thank you.
Sir, can I ask?
Yes, sir, of course.
Sir, if it is a person who was alive and there is a court order attaching his property for certain civil suit or any other, and there is already now and also simultaneously income tax demand raised later after that, but it did not pay to the court order. So now, as we said, in case of secured debt will have a liability of to borrow in this person's case, because liquidation provisions are separately saying secured creditors. Now, this debt of a court will be treated as a secured debt, or the first provision proceeds will go to the income tax because there is no IP filed or something. Because this happened with one of the case that he was supposed to file in a higher court, but in the meantime he died. Okay. So can his legal heirs file a case in the higher court, or directly the income tax provision will be subdued to the main the person who has won the case in his higher court, in the lower court, and no appeal was filed till his death? So will that person will get priorities over the income tax dues?
In my opinion, in case the tax liability is after, because you're saying that there's a court order already by this time during the lifetime of the SSC or the person, that a demand needs to be paid from, it can be as a secured loan, but we need to see that what does the order say? Does the order quantify the amount? Does the order say that, in case of non-payment, what will happen? Are all these clauses mentioned or not? We might have to see in that. But yes, in case there is a separate court order wherein the estate needs to pay so much of money, they may have to pay that. But the order of priority, I was also trying to understand, it's not been mentioned anywhere as to first whether you have to pay taxes, or first, in case of an individual I'm talking about, wherein first you have to pay taxes, and if there are, it can be considered as a secured creditor, in my opinion. Not creditor, but a secured this one.
I think that is laid down in the tax recovery proceedings. That it will become like a revenue due, like the.
But however, even though a lot of courts also mention that this amount will be recovered as a revenue due.
Yeah.
So then what happens? Which one goes first is a question that even I was trying to.
Yeah. I think this is also a question.
I wanted to include it in this one PPT, but I could not find the answer for it. So I thought.
So chairman has got a good case to defer his payments.
No, I'm sure we will find the answer. I was not finding too much time to continue my.
I know we had given you a short notice, Shashank.
Yes, sir. Yes, sir. Yes, sir.
I think chairman will be requesting more such sessions from you. Definitely, so that you can share your knowledge, and we will also be enlightened with your words of wisdom.
Definitely, sir. Definitely. It was a great opportunity for me also to interact with all of them. And I don't know how many people are watching, but I hope they have learned something. And if there's any mistake, of course, I hope that they bring it to our notice so that we can next time make it a better one. So.
Yes. Thank you, sir. Over to Secretary. Any more questions for the day from the
Any
members?
members?
One thing, Chairman, I would like to ask the speaker how to pronounce his surname, because in future we have to pronounce it properly. Somebody is saying Dandu, somebody I said Dundu. So which is correct, so that we'll make a note of it, and for next sessions we'll pronounce it correctly.
It is the Dundu Shashank.
Dundu Shashank.
Yeah.
Thank you so much, sir. My sincere thanks to the speaker, first of all, Dundu Shashank Garu, and the person who introduced him, Banu Rao sir, ex-chairman of the branch, and all the senior members who attended the session, Machar Rao sir, past chairman, and SSR Koteswara sir, past central member, Ramdev Budada sir, senior member, Saran Kumar Upalapati committee member, and all other senior members who have not raised their hands, and junior members. My sincere thanks for all for attending the session. We look forward to the same cooperation, sir, in future, Shashank sir. And with this, I request the branch to please share the virtual memento to the speaker today. Sir, this is a small token of respect from our branch side. Please accept.
Thank you. Thank you.
Thank you so much, sir.
Sir, I hope I will get a hard copy of it, because
Definitely, sir. Sure.
Yes, sir. Our chairman and secretary will see to it that it reaches your office.
Because what happened was, before 2 months, I was given the opportunity by ICAI
Warangal
branch to speak on a topic, and that was the topic on assessments and the procedure to be followed till Supreme Court. So that time they had told me that, they will frame it and give it to me. I have not yet received it. So,
we will ensure that you will get as a
Warangal branch also.
Warangal branch also. Both.
Yeah, on behalf of the Warangal branch
on
also.
a lighter note, sir, that's all.
Sharon, you want
Sir,
to say something? Tell me this. Tell us.
No, nothing.
Okay.
regarding our 27th program, Ravi, you can announce for the 27th program.
Yes, sir. We are having a big program on 27th by our MSME committee head office, wherein so many government authorities, government bodies, and trade associations are joining. So I request all the members to please join and support us in that activity. Please encourage your friends also to come. I think the communication also already sent from the branch to all the members. Deepak?
Yeah, sir. Just to add more to that, as we all know, Institute has started an MSME bus yatra that is traveling 75 days, 75 cities as a part of Azadi Ka Amrut Mahotsav, completing 75 years of independence. Wherever the bus is reaching, our local chapters are receiving it, and we are planning the programs along with the local trade bodies, banks, SBI, SIDBI, NSIC, Department of MSME, and others. So to create a bridge between the MSME, chartered accountants, and the local association and the financiers, so that MSME gets access to the more resources, and ICI is playing a pivotal role and acting as a catalyst and giving them the platform so that MSME gets benefit of it. So request members to please join on that 27th. It will be starting from 2 p.m. To 5 p.m. at Telangana Chambers, FTCCI, Federation of Telangana Chambers of Commerce and Industry. Will be a great honor to receive you on that day. Thank you.
Thank you, one and all.
Maybe one announcement on 28th program also, secretary, if possible.
No, chairman.
Okay.
I think deliberately stopped it. Maybe rethinking, because tomorrow we are having meeting.
No worries.
Then after we will announce.